Hello, my name is Hi6027. I'm gonna presentation my part is part A contact law on the option 1. According to the scenario, issue is in this case whether Suberger will be obliged to provide a grand prize with its Mazda CX-9 car. The rule is the formation of a contract is made through exchange of promise between offerer and offeree, which each can be enforced by law. In case of a commercial contract, the term can be enforced by law if they are not performed accordingly. In order to form a commercial enforceable contract, it will be necessary to ensure that essential elements of contracts must be presented in such commercial contract as required by the law. Those essential elements are considered as offer, acceptance, consideration, intention to create legal relation, competence, and legality of contract. An offer is considered as intentions expressed by individual to another to do or not to do anything. Acceptance is considered as acceptance of the offer made by the offerer to the offeree, and after acceptance, an offer become binding promise. Advertisement is distinct from an offer. And advertising or invitation to trade or not trade at an offer. If an individual accepts an invitation to trade, the latter will not be treated as a binding promise, as an invitation to trade is simply regarded as an offer made to make an offer. Therefore, it can be stated that acceptance of invitation trades will not be able to develop binding contact. In the case law is Pfister versus Bell 1961. However, not all advertisements are traced as invitation to trade. Some of them act as unilateral offer. In case an advertisement aims to provide any reward to any person against a specific performance, the same can be traced as unilateral offer. Unilateral offers can be made to the whole world, and the acceptance of such offer is made through performance of the terms. If a unilateral offer is accepted through performance, it will form a binding contract for the offerer. In the case law is Arrington versus Arrington 1952. In the application is, in the present case, it had been found that Suberger had made a promotional offer. It is unilateral offer. Mickey and Beth have accepted of offer through their performance, as they both have collected the coupon, acquiring golden scratch ticket and winning the golden car. The performance has been started before the company revoked the offer by starting the issue of printing mistake. Therefore, the offer cannot be revoked. So, the conclusion, the company will be bound to provide the grand prize a Mazda CX-9 car to both Mickey and Beth. Thank you.
my name is Sukhbir Singh and I am going to continue the second part of this assignment. The issue is to determine whether the director of Joytronics Private Limited Mercedes has breached the duty regarding to the care and diligence of a director. Rule. As per the provision which is set forward according to the section 180 of the Corporation Act, it states that the direction relating to different companies must perform their duty with due diligence and care. Application. According to the law, it was the duty of Mercedes to exercise the diligence and care before taking up the decision, and she should have taken up further inspection linked to other warehouse. Conclusion. Mercedes has breached the provision as provided in the section 180 of the Corporation Act. To determine whether any form of protection is available to Mercedes as per section 180 of the Corporation Rule. The definition of business judgment rule is provided in the section 180 of Corporation Act 2001 as per business judgment rules. If a director forms a business judgment, in such a case the law will consider that such director has complied with the duty of diligence and care. Business judgment will continue the following factors. Decision has been made in good faith. There is no material interest of the director in the decision taken. Directors have discussed among themselves about the various aspects of the decision as per their knowledge. Applications. Mercedes has decided to buy a warehouse in good faith. She did not have any form of material interest applicable in purchase of the warehouse. Felix informed her to make the decision as quick as possible. Mercedes was the opinion that the decision would be rational and good for the organizational working. Conclusion. Mercedes can get protection of business judgment rule as per section 180 of the Corporation Act. To determine whether Mercedes can be directly liable for the aspect of violation of the section 588G if Joytronics become insolvent. Rule. A director is directly prohibited from trading than the organization is involvement or in provision of being insolvent by the section 588G of corporation law. If it is found that a director fails in preventing the company from taking a debt and he was of the opinion that such debt would make the company insolvent in future, or if there were such reasons to believe that the company will become insolvent, on that case, it can be stated that the director has breached section 588G. Application. The decision of taking up the warehouse in Parameta was taken up by Mercedes jointly with Greg and Felix without conducting proper inspection of other places. Due to numerous factors which were of control of the business, has experienced poor financial performance in new location. Conclusion. If in near future, if Joytronics become insolvent, Mercedes would be directly liable for the breach of section 588G. Issue. The issue is linked to the present case. Would be the determine the liability of Greg in regards to duty of diligence and care of the insolvent. Rule. As per the provision which is set forward according to the section 180 of the Act, it states that a director relating to the different companies must perform their duty with due diligence and care. Application. Greg has not made any further inspection on the warehouse in the new location, instead agreed to decision taken by the Felix. Greg has failed to exercise care and diligence in taking the decision. Greg has not considered the feasibility of opening the business of the Parameta. Conclusion. Being a director, Greg breached the provision of section 180 and 588G of Corporation Act. Thank you.